Thanks for coming to Net Tuesday. And it's been my interesting little habit to try and find out for whom this is the first Net Tuesday that they've come to. You have to expose yourself by raising your hand. Okay, so that's 35%. About. Okay, well, welcome. So I'm going to run through this stuff very quickly before we get to our presentation. There are Net Squared groups around the world. They're all local, independent groups who do different things, but usually around the same lines. The way in which we think of ourselves here in Philadelphia is that we like the idea of trying to use the social web for social change. Understand that all those things are subject to lots of different meanings, and that's what we try and create programs that are relevant to that general theme. The main way in which we do that is with these Net Tuesdays, which happen on the first Tuesday of every month. And then the second Tuesday of every month we have a planning session, although next week it'll be on Thursday because of Election Day. We have a website you can go look at, as well as a Google group listserv that you can sign up for over there if you like. Here's a sampling of the last year of our Net Tuesday events. We've been doing this since 2008, and we try and vary both the formats and the topics of discussion. We're very open to new ideas and would love to help any of you to create a program around your interest that falls in with this theme. If that's of interest to you, we'll help you make it happen. Looking forward, those are the dates for the next Net Tuesdays. We're planning out what those are right now, and if you're interested in joining some of that planning, as I said, next week that should be Thursday, November 10th, because I didn't change that in time. We're meeting over in the lounge next to the Starbucks over on 16th and Arch. And everyone's welcome to join us if you like. It's very informal, and we promise not to dump all the responsibility on you if you come. We are streaming this out to the internet. These are 2 cameras here. If you would prefer to be off camera and not shown at all, try to sit over in that corner over there, and we'll avoid trying to catch you on camera. In addition to the stream that's going out, we are entertaining a Twitter back channel using a hashtag of PHLNET2. So there'll be tweets coming out from this room as well as from out there. And if there are people out there in cyberspace who have questions or comments that they would like to bring into the room, then they can tweet with that hashtag, and we'll try and get that into the room as well. In addition to the program and the topical aspect of what we talk about, we're also into the whole idea of trying to facilitate networking. So please sign in the sign-in sheet if you haven't done so. I will distribute just to the attendees here, I'll distribute people's names and contact information if they leave it there, as well as their business cards. If you leave a business card, including if you want to fill in a blank business card, that's fine too. And I'll scan those and send them back out to everyone as well. Everyone should be wearing a tag, which gives your name as well as something else about you that can facilitate some discussion as well as another networking opportunity. And we do enforce a strict no questions too stupid policy, so please feel comfortable asking whatever you need to be able to understand things for your situation. One thing that is unfortunate but is timely at this point is the passing of Rob Stewart, who was someone who had been involved with Philly Net Squared, but that was a very minor part of what he was doing. And we're collecting some donations. And Thomas, would you tell us more what's happening?
Sure. So Rob Stewart was a Philly transplant, but really committed to our city, and he was also really committed to nonprofit technology. And so what Net Squared here is doing of bringing together people interested in nonprofit technology as in the framework of local people coming together for mutual assistance are things that really embodied all of the work that Rob did. I won't go into all of his accomplishments, but Deb Finn, who's a longtime member of the national nonprofit technology community, wrote that Rob Stewart helped invent the job that I have. In the mid-'90s, he was one of the first people who was really working on bringing technology assistance and planning to small and medium nonprofits. And so I thought it would be fitting if we as a community made a single donation to the charity that his family named, which is the Logan Square Garden Fund, as a community to that fund. So there's a basket over there for that purpose. If you want to read a little bit more about Rob, I wrote a blog post on the PhillyNetSquare.org site. And if you're on the live stream or you want to make a donation but don't have any cash with you, there's a couple of ways that you can give online listed in that blog post. So I'll leave it with that, and thanks very much.
Something else that's timely is that the Social Media Plus conference is coming up in the Convention Center later this month. And as a special member of the Philly Net Squared community, if you use the discount code of PNS15, you'll get a 15% discount on registration for that event. Other sorts of things to know about, there's food over there, and we don't want to take any of it home, so we want to eat it all before it goes. I'm hoping a lot of the candy will be taken, but I think that's a lost cause. But please try and eat the other food. Almost all of the stuff, not the plastic wrappings, but the food and the cups and stuff are all compostable. We have industrial strength composting from this building, and so please compost that stuff. The bathrooms are outside, right past the elevators on your right. The room has Wi-Fi access. It's open. It's just under AFSC network. And if you've parked in the parking lot across 15th Street, you can get some discount. I forget exactly how much it is, by having it validated at the front desk. The sponsor for tonight is the American Friends Service Committee again, and they were able to pay for this food and the setup. And we have great support from them, as well as from the Friends Center, which is this building, of which AFS is one of the units. And one of the things I just wanted to say about the Friends Center, a couple things. One is it's a platinum LEED certified green building. It has 6 geothermal wells that go down deeper than the Comcast tower. It recycles its water from the roof is what flushes the toilets, and it's a very green sort of building, and they want to be able to respect that. The other thing that they've done that I'm quite pleased about is Friends Center and AFSC have provided significant support for the Occupy Philly movement down the street, and the kitchen over there is producing 1,500 meals a day from the Food Collective, and getting in tons of donations, and we're providing other sorts of meeting space and services as well, and that's just it's what they want to do, and it's been fun to work with that. And that's essentially it for now. What we're going to do is we'll just have a quick go-around introduction so people can say who they are and something very quickly about them, and then we'll get on with our program. What I'd like to do is ask people to use the talking stick, which will help with the recording. Not only we're streaming this out, but it's also being recorded and will be put on the website. So even though we can hear each other fairly well within the room, we'd like to ask people to use the microphone so that it can be picked up better on the stream and the recording. So, as I said, my name is Seth Horwitz. I'm an independent consultant under the brand of CommuniShare, and I do a lot of work here with the American Friends Service Committee in areas of knowledge management and online collaboration. So I'll just pass this on.
I'm Thomas Taylor. I'm the IT director at the Greater Philadelphia Cultural Alliance.
My name is Anson Hahn. I'm a full-time developer for the Star Group and a freelance consultant.
My name is Michael Schwartz. I'm a biotech consultant as well as a unemployed secondary school teacher.
Hi, everyone. I'm Wendy Univer. I have background in documentary filmmaking, and I currently work as the new media strategist for a small rabbinical seminary in, Wyncote, that has a strong bent towards social action in the rabbinate.
I'm Noah Furtman. I work at New York Life Insurance. I know Seth from Mishkan Shalom. and he's finally gotten me to come out here today because I have no idea and I'm just interested in it. So,
Surprise.
My name's Mary, and I'm interested in small to medium nonprofits.
My name is Mills, and I'm designing day schools for the children of opposing governments, beginning with one in Cyprus, to help resolve those conflicts.
My name is Paul Matheson. My day job is running a professional services firm, PJ Matheson. This year, we've been involved with a cause that you may be aware of a little bit. It's political redistricting that's going on all over the United States. We've been raising awareness about that and trying to inspire reform in that process. Along those lines, earlier this year, I did something to raise awareness about that issue. I ran one lap around the state of Pennsylvania, 1,000 miles from here to Pittsburgh, to Erie, Scranton, and then back to Philadelphia.
Just thinking about
That's a hard act to follow. Hi, I'm Mendel Polish, and I'm a digital literacy trainer with Philadelphia Fight.
Hello, I'm Shantae Miller, and I'm also a digital literacy trainer with Philadelphia Fight.
Hi, I'm Sean Needham. I work with Consumer Credit Counseling and Service, and I was just appointed to be their medium web specialist.
Hi, I'm Diane Reed. I'm Executive Director of CADE Kids, which is a social services agency working with Philadelphia students.
Hi, I'm Kathy Tillman. I am, amongst other things, a founder and director of Intercultural Coalition for Family Wellness. We have a local initiative in the Latino community training bilingual practitioners who work with undocumented families and youth in the three-county area. I'm also a Japanese taiko performer.
I'm John James, technically retired, and I'm updating my computer skills, learning Python, and working on a better way for artists to get paid for their work online.
Hi, I'm Suzanne Levy. I'm the new content director at generosity.org, which some of you may have heard of. It's a new site that's dedicated to telling the stories of non-profits and other organizations that are doing good things in Philadelphia.
Hello, I'm Stan Pokris. I'm Nonprofit Technology Resources, Executive Director. We have our own computer thrift store. Anybody needing a very inexpensive used computer should come to see us.
Hi, I'm Jim Worster. By day, I'm a senior software engineer for BNY Mellon, and by night, I volunteer to help people build websites.
Hi, I'm Mike Reichner. I do web and database development.
It's really hard to put yourself on camera at the same time. I'm Podcast Steve Lubetkin. I run Professional Podcasts by day and help Seth occasionally with the camera work, and people are seeing it on the screen right now because I can't get the camera to find me. So anyway, I do podcasts for organizations.
Hello, I'm Linda Lotz. I'm active with Haddonfield Friends Meeting, and we have a committee that's focusing on the legacy and current work of Friends in the area of worker justice and wage theft. And we're about to start a website, so the timing of this is great. Thank you.
My name's Cliff Stevens. I'm founder of Locadote, which is a location-based audio platform for mobile.
Hi, I'm David Greising. I'm a mediator, an arbitrator, a lawyer, and an author.
Hi, I'm Mona Gupta. I'm an attorney also, and I practice law in Center City, and I specialize in patents, copyrights, and trademark litigation.
My name is Tom Crispo. I'm Director of IT for United Way of Southeastern Pennsylvania.
Hi, I'm Greg Williams. Just interested in small businesses and nonprofits. I'm a software developer.
My name is Samantha McKnight. I'm interning currently at Gresson Law.
Mitch Collier, work with federal government agencies in health communications and policy issues, and also support my volunteer fire company with IT and administrative help.
Wasn't trying to rush you. Thank you very much. So Deni is going to introduce our guests tonight and the program, and it's yours.
Okay, I'll give a brief intro too. But first of all, I'm Deni Kasrel, and I'm the online and new media specialist for Health Partners, which is a nonprofit health insurer in the greater Philadelphia region. And I'm also on the advisory committee of PhillyNet Squared, so if you've been to these meetings, you've seen me likely more than once. Now, just a couple things before I do my intro. Number one, as Seth mentioned, the food over there. Please help yourself, and while the program's going on, if indiscreetly you want to get some food, that's fine. Also, as anyone who has been to any of these when I've been here knows that I always invite everyone afterwards. We go out, we have a good time. It's just fun. We go to a pub and have some laughs and get to know each other a little better. And every single one of you is invited to join us. So please do so if you have the opportunity. All right. So now just get to the program. And it's very timely that we're here the night after Halloween because we're in for a treat tonight. And that's because a number of people within our group have asked for a program on intellectual property, and so we did it. So as Seth had mentioned, if you do have an interest in the particular topics, let us know, and here's an example. This program is a result of those requests. So intellectual property, for those who don't know, and I'm simplifying it, and our experts will elaborate much more, but the very simplified version, it refers to creations of the mind. So right there, you know it's an interesting topic. And it refers to things that you create. So these would be literary or artistic works, inventions, symbols, names, images, and designs that are used for commercial purposes. And again, our experts will explain more fully what that means, but I think you get the idea, the general idea. And, of course, we have two lawyers here as our presenters, and that's because there are laws governing intellectual property. And they're going to explain what many of them are and the do's and don'ts, and how to protect yourself and how not to trample on someone else's intellectual property rights. And one of the reasons that intellectual property has become such an important topic is that now with the plethora of digital online content because of websites and blogs and wikis and social media and Flickr and you name it, e-newsletters, e-books, all sorts of things. It's just so much easier to publish anymore. It's just made it more common that just for just the average person or even just organizations, there's just a lot more things that you need to know and be aware of as far as intellectual property is concerned, because it just touches a lot more people than perhaps it did a number of years ago. So, for example, if you write a blog post and somebody, and this is not a hypothetical, it does happen, someone, say, just takes your blog post and we post it on their blog, then, you're someone who has an interest in knowing, what intellectual property laws are all about. On the flip side, say you have a website and you want to have a nice photo on it, and you go to Google Images and you search something and you just pluck a nice image off there that you see and you put it on your website, well, you could be infringing on someone's intellectual property rights. So you too also need to know about the laws that govern intellectual property. So I'm going to leave it to Dina and Alan to get into all the particulars, but just before we do that, I'll just do real quick summaries of their backgrounds. So Dina Latis, as you may know, she's been to a number of our PhillyNet Square programs before, and so she may look familiar, and she works for Greising Law, which is that a connection to you there somewhere? Yes. Okay, all right. And so where she focuses on intellectual property, new media, and commercial litigations. She also represents clients who appear before the Trademark Trial and Appeal Board, and in the past has worked for the World Intellectual Property Organization Arbitration and Mediation Center, and I'm only going to say that once. Okay, and next to her is Alan Lewine, who specializes in Internet copyright, information technology, and television production law, among other things. His involvement in digital copyright issue dates back to his work with a project that was called Cyberspace for Non-Lawyers, which was back in 1996, and for those of you who remember, those were the very early days of the Internet. So he's been there from the beginning. Alan is currently in-house counsel for a major Internet service provider here in Philadelphia. He serves on the board of directors for the nonprofit Center for the Copyright
Center for Copyright Information.
Center for Copyright Information, Inc. Sorry, I made a typo. He's also an accomplished jazz bassist and composer, and some of his recordings are available for download on the Internet, which actually will tie into our talk here because he has some of those licensed under copyleft, correct? Copyleft, which is an offshoot of copyright, and that'll be one of the topics that he'll be covering tonight. So, without any further ado, take it away, Dina and Alan.
Well, we're going to tag team on this a little bit. I'm going to speak for a while, and then Alan is going to speak for a while, and then I think we're going to have a Q&A. So first of all, thank you very much to Philly Net Tuesdays for having us. This is really great. And I am a lawyer, as you've all been warned, so I have to issue a disclaimer immediately and tell you that anything that I'm going to say right now does not constitute legal advice, and every situation is different, so there's that out of the way. On to more interesting things, I hope. Yes, next. Okay, so the topic of our presentation tonight is what every nonprofit and activist needs to know about digital content protection and infringement. My portion of the talk is really going to be to just give you an overview about what intellectual property is, what it means, what the different categories within intellectual property are. I'm presuming limited or no knowledge of this area of law, so that's where this is coming from. So another way to think about the title of my portion of the talk is the following. How do I copyright my trademark? This is something that I get asked a lot, and the answer generally is that you can't copyright your trademark. They're different things. They're different bundles of rights that have been created statutorily. So hopefully by the end of this presentation, you'll understand exactly what it means to copyright your trademark and why generally it's not really an option. So we're going to start with an overview of IP, the basics. Then move on to social media and other digital media content. Who owns it? How do you make sure that you own it if you're a nonprofit or organization that is using social media for your organization and you have employees who are contributing content or independent contractors who are contributing content? How to reduce your risk of liability as a nonprofit organization that has a digital presence, and top 7 tips what you need to do to protect yourself, to wrap up. So Deni gave a good definition of IP. Here's one that I found from Wikipedia, which is always a reliable source for such things. IP is a term referring to a number of distinct types of creations of the mind for which a set of exclusive rights are recognized and the corresponding field of law. It's possible that we took our definitions from the same source, I'm not sure. Okay, so IP includes four categories of law. The first one that I'll touch on is copyright. The duration for works protected under copyright is 70 years. It's 70 years plus the life of an author, or it's 120 years for works, 95 or 120 years for works that are anonymous, pseudonymous, or works made for hire. Just going to hit on the topics right now, and then we'll go deeper from here. Some of you might have heard of the Mickey Mouse Protection Act, which extended copyright in 1998 because Steamboat Willie was going to fall into the public domain. Oh, I just got louder. Previously, copyright protection was the life of the author plus 50 years, and it was extended in 1998. The next major category is trademarks. Trademarks generally last forever.
Can I ask a question now or later? Can I ask a quick question?
Sure.
I don't understand anonymous copyright. How do you copyright something if it's anonymous? If it's anonymous, who does it copyright it by?
Well, it's possible for a publisher, for instance, to put something forward anonymously.
Well, and it's something I'll address in a little bit more detail in the
That's
next
fine.
portion of the
Yeah.
program, because it's a good question.
It's a good question, actually, and I'm
It's surprising.
We'll touch on that. Great.
We were just checking to see if people were paying attention on that.
It woke me right up.
Trademarks. Trademarks are potentially indefinite. We'll just say that. Keep moving. Patents, the duration is 20 years from the filing date nowadays. Trade secrets are also potentially indefinite, provided that confidentiality is maintained. So, diving into an overview of copyright. What does copyright protect? It protects any original work of authorship fixed in a tangible medium of expression, including literary, dramatic, musical, and artistic works. So, for example, this could include websites, movies and videos, songs and sound recordings and graphics, photos, and computer software. Copyright rights exist from the time of creation, but there are certain advantages to filing a copyright registration with the Copyright Office, and it's easy to do and inexpensive. It's something that you can generally do yourself, unlike trademarks, which we'll come to next, which I don't necessarily recommend handling without an attorney. So to file a copyright registration, you go to the copyright.gov website, you submit your application, you pay $35, you submit a deposit, which is a copy of the work that's being registered.
Or two copies, I think. One copy if it's submitted online.
One copy if it's submitted online. And this is for an online submission. You should get your copyright certificate in about 3 months. If you do it through snail mail, then it takes about 10 months. So there's a real incentive to doing it electronically. And it's really almost as easy as 4 clicks of a button. It's pretty straightforward. So here's a long, wordy list of some reasons why you might want to file with the Copyright Office. Probably the most important one is that in order to file a lawsuit in federal court, you need to have a copyright registration. And Alan is going to provide a lot more interesting detail about copyright and the alternative licenses that are available. So I'm not going to say anything more about copyright, and I'm going to leave that to him. So moving on to trademarks. What does a trademark protect? A trademark is a word, phrase, symbol, or design that is used in commerce that identifies and distinguishes one party's source of goods or services from those of others. So what is that? What are some examples? Some common examples that we're all familiar with. Trademark rights flow from use in commerce, so trademark rights are potentially indefinite, provided that there is use in commerce. There are two types of trademarks. There are two types of trademark rights that you can have: common law trademark rights and trademark that's registered with the Patent and Trademark Office, the PTO. In the case of common law trademarks, rights are limited by geographic scope. In other words, you only have rights where you're actually making the use in commerce, whereas with a trademark that's registered with the Patent and Trademark Office, you have national rights, and there are other benefits as well, which I'll get to in a moment. To file a trademark registration with the PTO, there's a $325 filing fee for every individual class of goods and services for which you say that you're making use or you intend to make use. And there's an examination period. There's a whole rigmarole that you have to go through, basically, and it's important to make sure that you get your trademark rights, especially if priority is an issue. It's important to make sure that the trademark filing is handled properly. So just a few words about the different kinds of trademarks that exist and how protectable a trademark is. There's a spectrum of distinctiveness when it comes to trademarks, and that spectrum ranges from fanciful and arbitrary marks, which are considered inherently distinctive and are very strong marks, to suggestive marks, which are reasonably strong, to descriptive marks, which require sufficient use in the marketplace such that people start to recognize them and when they hear them, they think of that word as a trademark rather than a descriptive term, and generic words, which are not marks, which maybe were trademarks at some point but are no longer marks. So just by way of example, fanciful trademarks, which are coined terms that are made up. Some common examples are Kodak, Verizon, Exxon. Arbitrary trademarks are common words that have nothing in common with the goods or services to which they are applied. So, for example, Apple for computer products. Suggestive trademarks evoke or suggest some sort of characteristic of the underlying goods or services. So, for example, Coppertone, which has a typo, is suggestive for suntan lotion. And descriptive marks, common examples are Computerland for a computer store, Oat Nut for bread containing oats and nuts, Vision Center for a business offering optical goods and services. And a generic term is a common name for the product or service, and it can't function as a trademark. Milk to identify milk, bananas to identify bananas. If those were actually trademarked accordingly, then we would be basically taking those words out of the English language, and trademark law does not strive to do that. Yep.
So does trademark apply only to the textual representation, or does trademark also include the graphical representation of the mark?
That's a great question. I'm simplifying this a little bit. Trademarks can be both word marks and design marks, so it's possible those can be potentially separate registrations if you're filing a registration with the PTO, or it can be one registration. But you can protect the design elements, certainly.
And can I point out, it's not just visual representations. Harley-Davidson has a trademark on the sound coming out of their mufflers, for example.
And there have actually been
fragrances trademarked their scents.
Fragrances, exactly, and color combinations even that have been trademarked.
Perfumes, that's what I meant, yeah. The NBC chimes, another audio trademark.
I've heard on TV that the Occupy Wall Street trying to trademark that. In which category does that fall in?
It's an interesting question. I think that you have to have some sort of designation of source for a trademark, and I'm not sure if there's any consensus as to what that source is for Occupy Wall Street, so I'm not sure how much success they're going to have with their trademarks.
Yeah, who is what Occupy Wall Street that would
that protest? What?
Yeah, but who is what Occupy Wall Street?
I guess it's the people who are occupying Wall Street. Probably the communications working group of the original New York occupation.
Right. It's possible also just to mention for your entertainment, really, for marks to become generic, as I mentioned, this is known as death by genericide. So, for example, something that might have initially been a fanciful mark, a made-up term, becomes generic because the association between that word or term and the thing itself becomes so closely linked in the minds of consumers that there's no longer a difference. So, for instance, you might not know that escalator, aspirin, cellophane, yo-yo, heroin, and thermos were all once trademarks and are now all generic terms that are not protectable in the United States.
Well, and since this is a social activist crowd, I would just recommend a subversive course of action. A lot of the value of products are bound up in their brand names. You pay more for Kellogg's, some cereal, I can't think of any right now, than you do for the generic store brand version of the similar cereal. Thank you. Cornflakes. Good. So, there's several marks you can probably think of that are a little bit close to it, such as Kleenex or Xerox, that we use in non-trademark ways all the time in common speech. Now, if you use it in publications, you run some risk that they'll come after you with a nastygram. But if you just use it in common speech all the time, that moves it a little bit closer to genericness. Now, the owners of those marks don't want to tell you that, but you can consider it.
Quick question on that. If you're using it in a publication, suppose you cite them in the footnote or something, do you still need to go to them and solicit their permission to cite them and quote them or use whatever it is you're borrowing from?
You mean just to reference the trademark itself?
Right.
Generally not. There's a notion of nominative fair use. You can name the thing. There's no other way to name a brand.
Right.
There's no other way to say Coca-Cola except to say Coca-Cola, really, except to say, that high fructose corn syrup, sugary drink.
That's soda other
extremely
than Pepsi.
popular. Right, exactly. That's a more concise way to put it.
But non-trademark ways to use it is using Xerox as a verb, or talking about this as being Xerox or a handout or whatever. Using Walmart brand facial tissues and calling them Kleenexes. Those are the things that lead to genericide.
So what's been sort of the dividing line for companies that have websites that are strictly about, for example, other websites like Twitter or Facebook? Like the word tweet. What if you have a website, that word is in the domain name, and your whole site is about Twitter? And when can you do that?
You can generally do that if you're using the mark for a non-commercial purpose. In other words, an educational purpose, that would be acceptable. If it's for a commercial purpose, then you're free riding on their mark and they might come after you.
So if they're ads like, Google ads, no good, what if behind it the publisher is also promoting their services as a social media person? Become commercial?
The dividing line is likelihood of confusion. Are you using that other mark in a way that will make people think that you're endorsed by, sponsored by, part of them?
To really be upfront, if it's like Twin Philadelphia, you need to say this is no way associated with Twitter, Incorporated, right up on top.
That helps insulate you.
Yeah.
Don't use their logos, don't use their color schemes, all of those things help insulate it.
Just like with copyright, there are a number of benefits to filing a trademark registration. The ones that I want to highlight here are that it allows an owner to bring a lawsuit concerning the mark in federal court and possibly to recover statutory damages and attorney's fees. Another important benefit is that if you file a federal trademark registration, then your trademark is registered in the PTO online database, which means that theoretically somebody else who's getting ready to file their own trademark registration will and should do a knockout search of prior registrations. They'll come across your mark and they'll realize that you were there first and maybe they should pick a different trademark, otherwise they're going to be infringing. Also, the PTO is supposed to refuse to register any confusingly similar marks. Sometimes it's a judgment call, and the examining attorneys are obviously human beings, and they might choose to register or not register something they deem to be confusing if it's a close call. But oftentimes it's not a close call. So Again, it's good for the PTO to have your trademark on file so that something that's confusingly similar is kept off the lawsuit. So there's that. And I should just mention that there's a handout at the front that summarizes everything that's in this PowerPoint presentation. So if you need to see this list, you can have a handy copy of it and take it home with you. So moving on to patents, what does a patent protect? I don't think that this is going to be a big draw for this group, but generally patents are limited duration property right, and to be protectable as a patent, something needs to be novel, non-obvious, and useful. Not everyone is aware that there are business method patents that are offered in addition to what you might normally think of, mechanical devices or drugs or things of that nature. So, for instance, a much litigated patent was Amazon's patent on its one-click checkout system. That is patented technology. Trade secrets. A trade secret is any confidential information that provides a competitive edge. So it needs to be secret, provide a competitive edge, and be subject to reasonable efforts to maintain secrecy. And possibly one of the world's most famous trade secrets is what in the world is in that Coca-Cola formula. There are different kinds of agreements that you can have in order to protect your trade secrets. And I just flagged that for you. There's additional information in the handout. So we've talked about copyrights and trademarks, and patents and trade secrets, and whether you can copyright your trademark. Here's actually an interesting instance of when perhaps you can copyright a trademark. This is the iconic Betty Boop, of course, and this case, Fleischer v. Avella, involved a distant successor of the artist Max Fleischer, who in the 1930s created Betty Boop. And Avella, A-V-E-L-A, sold merchandise featuring Betty Boop images that it restored from vintage posters. And these distant relatives decided at some point that it would really be in their interest if they could collect the whole bundle of rights for Betty Boop and start to license her, license all the images themselves. So they thought that they did this, and they filed a lawsuit against Avella in California. The Ninth Circuit recognizes that you can copyright some elements of cartoons, provided that they are especially distinctive and that some sort of story is being told. And other circuits in the United States also recognize protection of our cartoon characters. But the Ninth Circuit basically said that because there had been, what had happened in this case was that Fleischer and his descendants and his family members in the 1930s had sold off copyright rights to Betty Boop to a large company, and then that company had then sold those rights to somebody else, and it happened that the chain of title at some point had been terminated because the copyright in the character had not been transferred. So, long story short, it turned out that Fleischer Studios, these distant relatives, descendants, did not have all of the copyright that they needed in order to successfully file a lawsuit against Avella. And it also turned out that they didn't have any luck claiming trademark infringement either, because the Ninth Circuit said that Betty Boop no longer functioned as a trademark. So maybe they could have had a copyright on their trademark, but unfortunately for them, they did not. So moving on to who owns social media and other digital media content. If your organization hires employees or independent contractors to write blog or website content, take photos, or contribute other substantive digital media content, or if you have and maintain a database of contacts that are accessible throughout your office, or hire a website designer to create your website, or you encourage employees to use social media on behalf of your organization, then you should make sure that any employment agreements that you have, both for employees and for independent contractors, very carefully set out who owns the digital media content, contacts, and websites, and use a work-for-hire agreement when it comes to independent contractors so that it's clear that the company and not the independent contractor has the rights to whatever is being created. And if importation of contacts from your contact management system into social media sites like LinkedIn, Facebook, and Twitter is important, and it is for many nonprofits. Obviously, that's where you might store donor information. Make sure, again, there that it's very clearly stated who owns the rights to those contacts and what happens to the contacts, what happens to that contact information when employees leave. So moving on now to how to reduce your risk of legal liability if your site accepts user-generated content. For instance, you have a website or blog and you accept user comments on your blog, as most blogs do, or you allow users to upload video, or you allow them to upload images. Remember the poetry of Donald Rumsfeld. The unknown. As we know, there are the known knowns. There are things we know we know. We also know there are the known unknowns. That is to say, we know there are some things we do not know. But there are also the unknown unknowns, the ones we don't know we don't know. In order to protect yourself from the unknown unknowns, it's important to do the following. Designated registered agent under something called the Digital Millennium Copyright Act, which I know Alan is going to elaborate on, in order to benefit from safe harbor provisions, which will reduce the likelihood of your liability for copyright infringement. This is a pretty simple process, and you can do it on your own, $105 with the Copyright Office. If you have users submitting a lot of their own content, you can ask them to sign on to some sort of user-generated content submission form where they are promising that whatever they're putting on your website does not infringe on somebody else's copyright. You can also protect yourself in the privacy policy in terms of use, those little disclaimers that are at the bottom of many websites. So if your website has any social media functionality, for example, the ability to like the content of the site through Facebook, or it allows users to contribute their own content, or users are contributing any personally identifiable information about themselves, you want to tell users how you're going to use their information, and you also want, in the privacy policy and in the terms of use, you want to tell them how they can use your site. And you can also, generally in the terms of use, warn users against making defamatory remarks or any other illegal, or taking any other illegal acts in your terms of use. So, to summarize, the key considerations for protecting your organization in the new media age. File for copyright registrations in order to protect your original content, including website content, blogs, newsletters. File for trademark registrations in the United States, and if you're an international organization, consider applying and filing abroad as well. Register your primary domain name and popular variations of your domain name for your organization's website. And in some cases, you might even want to consider country code top-level domains for other countries if you're an international organization. It's also important to make sure that you know in whose name your domain name is registered and what happens if that employee leaves, and to track any domain name expiration dates, because it's really a pain if your domain name expires and somebody snaps it up and you have to pay a lot of money to get it, or you have to rebrand. Yeah.
I'm a little bit confused about how you file for copyright registration for something like a blog where the content is constantly being updated?
Yeah, that's a good question. There are different ways that you can do that. Some blogs will file copyright registrations on a periodic basis, or when they make. If you contribute to your blog only occasionally, then you can file when you make a meaningful update. If you're blogging on a daily basis or on a weekly basis, then you might consider filing a registration once every 3 months or once every 6 months, so that you are capturing your most recent content.
So that's the same process that you described earlier on the .gov website. Every
Correct.
3 months, you pay $35 and do that?
That would be a proactive, probably hyper-proactive way, but that is something that some blog owners will do.
How do you provide, what do you need to provide in terms of a copy of your website if you're registering a site that's managed by a content management system? Like a blog, like a WordPress blog, like what do you submit as a copy of your content?
Let me. If we get into very detailed examples, it's a little bit hard to answer with any specificity. The Copyright Office. Well, the last time I talked to David Carson, who's the general counsel there, was about a year ago, and they were still in the process of updating their mechanisms of registration and submission for continually updated online content. And how you go about this might have to do with how valuable the content is and what your budgets are. The Washington Post may do it one way. A small nonprofit might do it another way. There are streamlined mechanisms. I don't know if they finalize their process because I don't deal with day-to-day registrations, frankly.
Yeah, one thing that I've done with clients in the past is you can create a file using Adobe PDF that's an entire snapshot of a website and submit it that way. Capture everything.
Are you retracting your question?
Well, I was going to follow up his question. You sort of answered it. I think what he was asking was, a lot of these publishing platforms these days store data, store like blog posts and things like that in databases, and it's not necessarily easy to get it out. So the question is, how do you submit a database full of blog posts to fulfill the files?
Well, if you have your own copies of it, you keep a local copy of your blog, that's one easy way. And of course, posts that aren't yours, you can't copyright anybody else's work. Unless, well, I won't go into edge cases right now. The Copyright Office website has pretty good guidance on, detailed specific cases.
But continuing to evolve and improve.
On the terms of use, how important is it to make the users check the little box and keep a record of that, as opposed to just having the terms of use stated?
Well, in my view, and I advise my clients about this frequently, it depends on what you're doing with them. And because you're asking a lawyer, the answer is always the same. It depends. Depending on what you're asking them to agree to, if it's a little bit unusual, I think it's important to have a checkbox in the flow. If it's more or less standard terms of service, I think it's adequate to have a link that's easy to find at the bottom of every page. When you initially sign them up, it's probably a nice idea to have them as part of the registration flow. Preferably have a checkbox that's the default is unchecked. They have to take an action to check it. I have read and understand and agree to the terms of service, and that word terms of service can be linked. An even better way, and sometimes we do this with software click wrap licenses, is present the terms of service in a window, have a way to print it out, require the user to pull the scroll bar to the bottom, even though lawyers like me who spend hours and hours laboring over writing these really nicely know that nobody's going to read them. And then once it pulls to the bottom, then the checkbox is enabled. You pull it to the bottom, then you click, and click accept. Or if less friction is appropriate for what you're doing, I think maybe you say, as part of the sign-up registration, you just have the little link. I acknowledge that I'm subject to the terms of service, but without a separate checkbox. So that gives you a realm of possibilities without giving you an answer. Should we
move it on?
Keep moving and then
Okay.
Can the rest of you
hold that, or is
Yeah. It's related to that last question.
Oh, is it? Okay.
Specific question. A relatively common case is requesting some assignation of rights in your terms of for user-generated content. You're asking for some assignation of license from that user. Is that a case where you're more likely to want an affirmative action rather than a terms of service?
Not necessarily, because the scenario is getting very common. I mean, you need to have the right to display, to use their stuff. Sometimes sites have said, okay, if you submit something, I own it. That's awfully aggressive and doesn't necessarily hold up. But if you're going to be that aggressive, yeah, you definitely want to say, oh, and I would call that kind of a term out. Yeah, and if you submit something, we own it and can do whatever we want with it. Republish it, make $1 million from it, and you understand and agree to that, because I'd say that's an unusual term. I'd love to have questions and discussions, but...
Okay, so we're just going to... can we stand... Well, stand as
There'll be more time.
Okay. Can we just get into his, or can you hold that or not? Or is it so timely that it...
I'll just hit the last 4 of the 7 very quickly. Make sure to update your employee and independent contractor agreements. Consider having an employee handbook and reviewing and updating that. The website privacy policy, terms of use, and the DMCA. So that was the full sum. And
Thank you. And Alan's next, and we will also have time for just general Q&A. So I'm sorry I didn't just kind of want to get him moving on his portion, and it may actually address some questions that people were thinking of asking. But anyway, in any case, you can still ask him while he's going through his presentation, and also at the end. Again, we'll have open forum for questions for either Dina or Alan.
Well, and Deni, we're running a little long. Should I still plan on pacing myself for a half hour, or do I need to tighten it up?
Oh, no, you have a half hour.
And thanks for the questions, everybody. I've already been introduced, and thank you for that. This being the day after Halloween, I thought I'd wear the scariest costume I could think of, so I came dressed as a lawyer, and I see it's working. And I'm basically here to talk a little bit more specifically, and we started edging into a lot of this, and I appreciate the questions and the discussion. I will break every couple paragraphs and invite you to ask questions, but also feel free to jump in and ask me questions. But I might hit a number of the points because we were edging more toward copyright questions as we go along. So I'm going to start out by reiterating something that Deni said. Yes, I'm a lawyer. I am senior counsel for Comcast, although because I'm a lawyer, I also have to give a disclaimer. Not only am I giving you legal advice, which is particular to particular situations, and I'm speaking in generalities here, I'm also not here representing Comcast or their positions or the Center for Copyright Information or their positions. You might have heard of that organization, and I'll talk about it briefly as well. But this is just general advice for a like-minded group of friends, I hope, and a little bit of a sense of the lay of the land. And before I became a lawyer late in life, my first career was as a jazz musician and composer. I have a site up on MySpace, and I was going to, I timed out, show you what I mean, if this plays. It may take a minute to buffer. But the site on MySpace, I've got my compositions on it, for the most part, performed by musicians I worked with. They were once released on CDs and cassettes, but are now pretty much only available through this sort of site. And I make them available. It'll probably start playing in the middle of when I'm talking. I make them available for streaming or download through a sort of copyleft, as it's sometimes called, license. And it says right here in my bio, right here, I say, oop, I'm too used to a mouse to use just a laptop without it. There we go. What it says there is that the music available here. There it is. Oh, thank you. Mouse isn't active yet. This is a composition called Wow Cow, which I wrote for my drummer, Cal Haynes, who is here sort of featured in this. Let me bring it down just a little bit. So what I posted on here, which is basically the right statement, the music available here may be downloaded and shared for your personal non-commercial use by all at no charge, but please keep the attribution of the artist and composer intact if you wish to make other uses of Alan Lewine's compositions or performances. Particularly, I didn't write this in specifically, but particularly commercial uses, please contact me. So if you figure out a way to use my stuff to make $1 million, I think that's great. I just hope that we can find a way to share the revenues. And I'll pause this so it doesn't become too much of a distraction. There we go. So I was playing bass on that. By the way, I wasn't that great sax player or drummer. That was somebody else. Thank you. We'll pass the hat after the show here. I've got a bunch of tabs lined up here on this browser, and I'm going to go through some of them. And I'm going to start by talking a little bit about copyright basics. What is copyright? Dena mentioned the Digital Millennium Copyright Act, which we tend to call the DMCA. I'm going to briefly mention fair use, and I'll bet you have a lot of questions about fair use, but we could spend a couple hours discussing that. So I'm going to briefly mention it and try to keep moving. And then we're going to talk about, I'm going to talk a little bit about different views of copyright, and I've got some examples, the ISP's way of thinking of it, and I've worked on the ISP side of this issue since the mid-90s, really. Excuse me, that's a little bit of a cold. I hope to share copyright information, but not the cold with y'all. So I'm going to suck on a Ricola brand, trademarked, cough drop. So ISPs, that's the internet service providers. You might get your internet service from Verizon, Comcast. There's any number of them. Seems like less every day. Whether you're an individual or a business, you probably want to be connected to the internet in some way. The big content industries have a view of copyright also. The Motion Picture Association of America, I'm going to talk about a little bit, the Recording Industry Association of America also. Just to give you a lay of the land, and as you might imagine, content creators, whether they're spending $150 million to make Avatar or just releasing the latest Lady Gaga single, have a strong interest in maximizing their control of the products that they try to monetize. But there's another model that works for a lot of people that we'll talk most of this session about. It's what I've called copyleft, making a little play on the term copyright. And of course, copyright doesn't mean right or left. It means the rights to control copies of your work. The most common model of that now, and the best thought out, I think, is known as a Creative Commons license. So I'm going to give some examples of that, and if we have time at the end, I may talk a little about the difference between copyright infringement and plagiarism. I'll also point out, I hope you got it as you came in, if not as you go out. I brought a book written by a cartoonist friend of mine, Nina Paley, called Intellectual Pooperty, which takes an amusing look at some of these issues as well. She makes this available on a copy left basis. You can download the PDF and print it out and do whatever you want with it. Or for basically the cost of printing the books, you can buy them, and it comes with the creator-endorsed seal of approval that the author actually endorses this copy. But I'm getting ahead of myself. I've got to the end of my presentation already, so let me start at the beginning. I'm going to repeat a little bit of what Dina said. The basics of copyright is that it protects the expression of an idea in a tangible medium. Now, that's a lot of legal words, which I'll try to unpack gently. First of all, there's an important distinction in copyright law. Copyright only protects expression, not ideas. That's a seminar in itself, that distinction. But the ideas, say for a new type of cotton gin, is protected by patent typically. However, if you make a drawing of it, that drawing is something you would protect under copyright. The idea of down on his luck detective having a beautiful dame walk into his office and drinking whiskey while solving her murder mystery is an idea. It's not protectable under copyright. Sam Spade is. And to some extent, as Dina mentioned, copyright covers a lot of things. When I say tangible means of expression, typically that meant writing on paper once upon a time. It's been expanded quite a bit. It's tangible if you put it on a computer because it's inherent in the way the random access memory or the hard disk has its electrons lined up. That's considered tangible. So, without going into too much detail, how you express your idea is something that is subject to copyright. Copyright's automatic. As soon as you put a doodle on the paper, you own the copyright in that doodle. It's true that in order to sue for infringement, you have to get a registration first. If you get a registration early, you get access to what they call statutory damages. Congress, over the last bunch of years, has been ramping up what they call statutory damages. In other words, you can be charged $75,000 for each infringement under statutory damages and get legal fees. Otherwise, you can still register on the way to the courthouse to file your copyright lawsuit, and you pay a few $100s extra for expedited registration, but then you have to show actual damages. How much money actually came out of your pocket because somebody else infringed your stuff. Now, copyright is real. It's a genuine legal doctrine, and if you take somebody else's stuff, you can get sued for it. And if they had registered their stuff early, like the movie studios and the big record companies do, your damages assessed against you can be astronomical. You've probably heard of some of the RIAA cases and the damages that have gotten assessed in those. Which is why I wanted to make the point is that taking other people's content is usually called piracy. And so I brought my other Halloween party. If you don't want to be labeled a pirate, you don't want to be at risk of expensive legal proceedings, get permission first. Get permission first. If it's depending on the type of use and the value of the thing you want to use, the cost might be moderate. Yes?
A person becomes famous for an act that they have, public act that they have performed, let's say, and they become a hero in people's eyes, and they write a book about that experience. If I want to write a play based on this person and their experience, do I have to get their permission first because they've already written a book about the experience?
Well, there's a couple of things in there to consider in that specific example. If you're basing your book on your play on the book, then you need permission from the book's authors, because one of the rights under copyright is the right to make derivative works based on previous works. Facts themselves, if this is a true story, are not protectable. Facts are facts.
So it's like a fine line there.
It's somewhere between a fine line and a big fuzzy gray area.
Yeah.
And then the other thing to consider is the right of publicity, which is another sort of intellectual property right that's more powerful in some jurisdictions than more recognized in some jurisdictions than others. However, if you want to say Tom Cruise likes my play, you probably need his permission to do that. If you want to have Albert Einstein appear in your play, a character based on Albert Einstein, you actually probably ought to get permission from the Einstein estate, which actually has a licensing business around the caricature of his character, which you see a lot of times in commercial applications. If you're doing something that's completely non-commercial and flies beneath the radar, well, you can say, well, the risk is pretty low and the damages are low even if somebody tried to nail me, but if you get dragged into court, that's probably a fight you can't afford to win, even if you win it. So those are things to think about. There's a lot of balancing, and I'm oversimplifying a lot here, of course, but I hope that helps.
Thank you.
Going on, one of the things that was negotiated back in the mid-'90s, between about 96 and 98 when it was passed into law, was the DMCA, the Digital Millennium Copyright Act. I was at PBS at their headquarters in Alexandria, Virginia at the time, working on developing and launching PBS Online, which was really the first major media site to have an online presence like that. And while PBS wasn't directly in the negotiations, I was tracking it on PBS. The negotiations were primarily between the big telephone companies, which provided dial-up service, and the big content companies, represented by the MPAA and RIAA. This took 2 years and a lot of hard work, and finally a compromise law came out in 1998, the DMCA. It has two main parts, but I'm going to talk right now about Title II, which is Section 512 of the Copyright Act, which says basically, and I can show you what it looks like, but I'll get to that in a minute. It says basically that if you're an online service provider, you're hosting third-party content, you're permitting third parties to post stuff, and those third parties that are using your site to post stuff are posting infringing stuff, the owner of the content can send you a notice in a certain form that's detailed in the statute. Oh, there it is. I forgot what page I put it on, so we'll get to that. I'll provide some links later. Basically, the content owner can send a notice to the ISP, say, this stuff infringes my content. The ISP has an obligation to block access to it and let the person who posted it know. Then they have the option to put up to send back a counter notice that says, no, this isn't infringing, and you need to put it back up. And you also need to, until that happens, the ISP doesn't reveal who the person that put it up is typically. Because all the content owner has usually is an IP address, and those are assigned dynamically and randomly. So just because they sent a notice and your ISP forwarded it to you doesn't mean that Universal Pictures knows who you are or your address. If you put up a counter notification, though, you have to say yes, and you have my permission to give them my address, and I'll go meet them in federal court if they choose to pursue that. That's how it works. It basically takes either a counter notice or a subpoena before responsible ISPs will give up private, personally identifiable information. There's a lot of reasons for this, including the law, the statute, privacy policies. Certain cable companies and telephone companies have particular statutory rules about how they have to protect their users' privacy as well. So, without going into privacy policies, which again is a whole other subject, that's the basic deal. And if the ISP complies with this and puts together an effective policy, they're protected from liability. The content owner can't say, hey, you're hosting it on your site, I'm suing you. You're making it possible. So that's the trade-off. That's the deal. Now, unfortunately for the content industry in particular, about a couple months after the DMCA became law, Napster was launched. When the DMCA was being put together, nobody was thinking about peer-to-peer connections, which are not really covered by the DMCA, and has been a source of a lot of frustration for the content industry. Now, infringement's still infringement if you've got unauthorized copies, but the ISPs aren't able to help. And most ISPs in this country aren't able or willing to block access to places that have, among other things, a bunch of infringing content. So it's been stymied a little bit, and jumping ahead just a little bit, this is where the Center for Copyright Information came in. This is another multi-year, about 3-year negotiation process between major ISPs and major content trade associations that are looking for a way to help shape user behavior and educate people. Well, you know, you actually can download that stuff at a reasonable price. It's available in these places. When Napster came out, it wasn't available at all online to get that kind of content. But the content industry is learning how to license and the value of online distribution. And users are, I think if it's reasonably convenient and reasonably priced, people are glad to get legal copies and not go through the hassles. Now, jumping on, I'll mention the Copyright Office. There's a nice circular from the Copyright Office called Circular 1 that covers copyright basics. It does a pretty good job of doing it in plain English. Also, the Copyright Office, which is copyright.gov, by the way, also has an HTML page, for instance, that says, what is copyright? What does it protect? So they've got some good information there. Most ISPs have acceptable use policies as well as terms of service. And it's something I recommend. I think a lot of people in this room are involved with organizations that are probably hosting websites of one sort or another. It's probably a good idea to have some terms of service and to have an acceptable use policy. Especially, I think it's required if you have users that you're allowing to post content to. One of the things that you put in the acceptable use policy to show that you have effectively complied with the DMCA and then therefore are protected under its rules is something about, how your DMCA compliance works. This is what Comcast does. For one example, and I just chose this because I helped write this section. Doesn't mean it's the best one out there, but it's one example. It says what our policy is, how do you report infringement if you're a copyright owner, and what do we do with that information, and how can you make a counter notification, which is this last paragraph right here. The fact is, Comcast typically gets over 1 million notices a month of alleged copyright infringement. We get a handful of counter notifications. This process is all automated. It's still expensive to deal with, but it's all automated, so it's possible to deal with it at least. Now, Comcast also has almost 20 million households using us as a ISP around the country. So the numbers are astounding. But that gives you some idea of that. Now, some different views. This is the Motion Picture Association of America. They represent the big movie studios, or trade association. They have a copyright page. Their position is pretty clear. They say, you know, if you use anything without authorization, you're a thief. Copyright theft is our biggest problem. The content industries, whether the MPAA or the RIAA, tends to come up with numbers that calculates how many dollars it costs them as if each download or partial download was the loss of a full price sale of a CD, of an entire CD or an entire video. And somehow we have some mechanism of calculating jobs lost as a result of this. And I don't quite understand their numbers, but they have a point to make. And there's a good basis under it. They make it by using, as some social activists too do, also numbers that suits their purpose. You know, they find the best statistics for their own purpose. But they have a good section to explain some of this. Likewise, the RIAA, which represents the major record labels, has a good section on this and talks about what is online piracy. For example, you make an MP3 copy of a song because the CD you bought permits you to do so. You can rip it to your hard drive, to your computer, and then put it on your iPod. That's fine. Then you put that recording up in your shared locker for online backup and make it available to everybody else to download. Now you've sort of crossed the line, the way the law's written. So that's one example. Is it different than mixtapes? To some extent it is. You know, those of us that are old enough to remember when we'd make a mixtape to give to our girlfriend or whatever. And that it's so easy to do and so massively distributable with modern technology that the content owners feel like it makes a difference. In fact, I was looking at something just today, an interview with Pete Townsend. Again, those of you that are old enough to remember, he was talking about my generation. He was the lead guitar player and really the leader of The Who. And, you know, I feel bad for people that had great success under a different social contract where online distribution wasn't even contemplated. You know, where people coming up today are finding different ways to deal with it. But I'm going to read just a short paragraph from his interview. Whether the public listen or not, creative writers and musicians should get paid if their work generates money by virtue of its existence on radio, television, YouTube, Facebook, or SoundCloud. It's tricky to argue for the innate value of copyright from a position of good fortune, as I do. But he says, I once suggested on a forum that people who download my music without paying for it may as well come and steal my son's bike while they're at it. One woman was so incensed that she tried to argue that she was still supporting me as an artist by sharing music with others who would eventually filter down maybe some cash in some form or another to me that would pay for my son's bike. He wasn't buying that argument. Needless to say, he says, now I'm being facetious, but some things really are worth stealing. A creative person would prefer their music to be stolen and enjoyed than ignored. This is the dilemma for every creative soul. He'd prefer to starve and be heard than to eat well and be ignored. And that's probably true, and that might apply to some of what y'all are doing. When you're blogging, when you're creating content, you want to see it widely distributed, I assume. As such, that's my little... Oh, there's the DMCA. It's a PDF that goes this long.
Like the terms of service a lot that you see on the ones you talk about checking off.
So there are nuances and subtleties in the DMCA I didn't deal with. I'm going to play you. Actually, I'm going to come back to that. There we go. I'm going to introduce you right now to a site called Question Copyright, questioncopyright.com. My friend Nina Paley, who is the artist that did this book, is their artist in residence and distributes things, helps them promote some of their ideas in different ways through interacting with this organization. This is one of the ways, intellectual property, as she calls it, and distributes all of her stuff, including her acclaimed, award-winning film, Sita Sings the Blues, for free use, free reuse. She also sells DVDs for money, and then you get the little artist-approved sticker on that as well. And has designed a bunch of these T-shirts. Now, you got to pay for the goods, but she's not asserting her. She's made a choice not to assert her copyright in this stuff. A lot of this stuff is licensed through an organization called the Creative Commons that was started by Larry Lessig and a group of students at Stanford University, and they built a model based on there are some programmers in here, I think I heard. So some of you might be familiar with open source licensing under the GNU public license or similar public licenses. Well, that's an early form of copyleft. Copyright's automatic. It's a way of using copyright law to say, I'm not going to enforce some of my rights. You can freely copy this. You can freely redistribute it. You can freely make modifications of it. But you're expected maybe to put the notice on there that whatever you embed this in is subject to this open source license also. Maybe you want attribution of the original source. Maybe there's an obligation to contribute back to the source code. Lessig took this same idea to build a set of copyright licenses under the name Creative Commons and make them available. A lot of people are using it. For instance, whitehouse.gov has a copyright policy that uses a Creative Commons Attribution 3.0 license. And I'll talk very briefly in a minute here about the different kinds of Creative Commons licenses. They basically come with a deed. This is the Attribution Share Alike license, which Nina uses, for example, that very briefly summarizes the rights that are laid out. For instance, this license permits you to share, copy, distribute, and transmit the work, to remix it, in other words, adapt it, make derivative works, build on it, make versions of it, and the right to make commercial use of the work, but it has some conditions attached. Attribution. You must attribute the work in the manner specified by the author or licenser, but not in any way that suggests that they endorse you or your use of the work. And under a share-alike license, which basically means this license flows through to wherever you distribute it.
Aaron, can you just give an example of what either of those might look like in terms of explaining what the attribution was?
Okay, sure. That's a very good point. Attribution, it's a sort of what the French call, I forgive my pronunciation, a droit moral, a moral right, the right to the identification of the author. Perhaps the identification of the title of the work. If it's a musical work, it might be the identification of the band. Who's the work attributed to? What's the source of the work? Who's the original creator? And that's the attribution license. And the share-alike license says, you can resell, redistribute, modify, and reuse this work, but whenever you do that, including if you incorporate it into your own as a modification and make a modification, therefore, that modification is subject to the same rights. You can't say, okay, I've incorporated, to go back to your example, all of this dialogue from the biography, the book, into my play, and now I'm going to copyright and say it's mine. And that's the sort of limitation there. Now, this comes with more detail. as they call it, the legal code. And so there is the actual license agreement that goes into more detail on it. What the White House uses is the Attribution 3.0 license, which...
Can you scroll up? Because I think there's
Sorry?
an interesting fact up at the top of that.
The top of this?
Right. So the government produced materials.
Mm-hmm.
Which means, right, so copyright doesn't apply to government produced material.
If the government produces it, it's a public domain.
Right. Which, interestingly, probably is why Deni can't get in any trouble for having used Secretary Rumsfeld's poetry.
True.
Although another reason is that he actually didn't put it in a tangible medium of fixed expression. That poetic, open, free verse rendition was courtesy of Slate magazine, and they were given a credit. And so I would argue it was fair use if they were to question me about it. But he said those words. He didn't write them down. Presumably.
Right. Simply saying the words, even over a microphone, doesn't give you a copyright in them. Now, this is being recorded, I understand, and will be streamed later. You know what? I'm not going to own the copyright in my words in the presentation. The fellow over here that's running the recording device, or whoever he's working for, actually would own the copyright in the presentation. To the extent my words are the presentation, they're facts. And I can use them again. The words, the ideas, the concepts, the fact that I'm doing this. So this is where we're getting into that bright line of a big gray fuzzy area. If that hopefully confuses the issue further. The thing about copyright law is, and I hope there's no tax accountants or lawyers in the room, but it's right up there with the tax regs in complication. It has been complicated and tweaked. Brief detour into history. Copyright law started in the early 18th century in England with the Statute of Anne in 1706, I think, something like that. Copyright law has always responded to, chased, and never caught up with technology. What instigated copyright law in the very early 18th century? Well, printing presses were becoming affordable. This made the publishing industry, which was the scribes, nervous. And just think about the job loss connected with bringing printers online and putting scribes out of business. And not to mention that the first thing that they printed, the second thing was probably the Bible. The first thing they printed was porn, which disturbed other people. Oh, I'm sorry, yes?
Yes.
Really, this question should have been at the first part of this, but what is the purpose and the use of the copyright symbol?
Well, that's a good question. I'll answer it briefly. It's not required. Since we joined the Berne Convention in 1989, I think, in 1989, copyright is automatic. The purpose of the use of the symbol first, the proper use of it is the C in a circle, followed by the year, followed by the organization that owns the copyright. Copyright 2011, American Friends Society, Inc., for example. The purpose of it, though, is to give people notice that you consider it copyrighted, that you're probably going to enforce your rights. And beyond that, it's not a legal requirement.
For websites, there is an advantage as well because you can tell viewers when the last time the website was updated was. Oftentimes you'll see the copyright symbol 2009 to 2010. So you know that the website was updated during those years, created and updated, and then perhaps, presuming that that information is accurate, it hasn't been updated since.
So, yes.
I just wanted to share with the group that the Center for Social Media at American University has a really fantastic repository of information on fair use, and there's a lot of confusion about fair use. So it's centerforsocialmedia.org. A lot of great downloadable information.
Yeah, it's a great resource.
Yep, there are some other good places too, but And I kind of skipped over the fair use altogether because I was afraid if I started on it, we'd never get past it because I know it'll generate a lot of questions. But, so if you have a fair use question, let's hold it for just a second. I want to hit a couple other points and open it up. But if you want to ask a question, otherwise, please.
Well, this might tie into that actually, but a lot of us here are on social media. I'm wondering what are implications that are with social media and the websites we have. I guess what are things to watch out for, and what are some things to consider when using social media like Facebook and Twitter and posting content, things to watch out for? Like maybe, I guess, what are things not to do if we share something? What are things we should be sharing or shouldn't share? Those two something like that.
Well, yeah, you can't really do it on Twitter, but you could on Facebook. You probably shouldn't put Lady Gaga's latest hit up there.
Okay. We're not going to, but
I don't need to know.
Honestly, I still encourage sharing, but like if you want to share a website, for example, is there any, I guess, if you're just sharing it for the sake of sharing it, could somebody say we shouldn't do that, or that's our site to have, and what are implications there, perhaps?
Well, again, this gets fact specific very quickly. So just at a high level in general, I'd say post your own stuff, write your own post, draw your own drawings that you're going to post up there. If you want to refer people to other content, I'd do it through a link. You got to check this out. Put the link in.
Okay.
What about when someone's posting to your site? I mean, that's what you're talking about. What liability? Say you ask for people to send in their photos or whatever it is. They're sharing content on your site. That's the flip side of it. What is the issue? Whether who owns that content once they post it on your site?
Whoever took the photo owns the content.
It doesn't matter. Once it goes on your site, it doesn't like.
Unless you have an agreement with the poster that says otherwise. And copyright's funny. It's like real estate and copyright are the only two things. You need something in writing or it doesn't count the transfer. You can't transfer ownership without a writing. Now, as far as your own site, this is where it's really important to have terms of service and or acceptable use policy and some way of dealing with it if you get claims from third parties that they own it and it's infringing.
Like a DMCA agent.
For example. Sure, yes.
I'm sure this seems like it doesn't relate, but yeah, why? I'm just wondering why it's so easy to copy things from, like you can literally like copy and paste from blogs. I write a blog, and I can go in and just copy and paste it when I'm not signed into it. So anybody could just lift something, a long passage I've written, and paste it in somewhere else. I'm wondering, why does the software allow that? I'm on Google, as many people who do blogs are. I'm just wondering, how am I as an individual going to protect myself or my work?
It's the nature of the technology, and this is why content creators are a little crazed over the last 10, 15 years.
Yeah.
Although there are some developments in the technology that are making it possible for people to track their stuff online. I don't know that this is the case so much with text, but there are watermarks that people put on their images. There are watermarks that people put on their music now increasingly, so that you can find out, you can send something out into the internet to bring back all the instances of your copyrightable material online. So presumably that's going to continue to evolve and improve.
Yeah, there's ways to tag, and this is something that before the internet was even an issue, I used to advise software developers. Put some unique stuff in your comments fields or put a non-functional routine that doesn't interfere with the running of the program and isn't required for the running of it. Some lines of code in there, because then you can search for it and say, because the other guy will say, oh no, I made that up myself. And I say, well then why does it have this in there? So that's an enforcement issue. It's not a protection issue.
Yeah.
So much.
Okay.
Protection is hard.
Okay. Seth has been raising his hand.
Oh, I'm sorry. I'm not looking in that direction.
Okay.
I know there's another specific example, but it's illustrative. When I was hastily putting together the PowerPoint for this evening's I wanted to find a picture of Rob Stewart, and I searched for it. And I'm used to in Google Images of finding the advanced search tab and being able to look for permission.
Creative Commons.
That's a Creative Commons sort of thing. But for some reason, I couldn't find the advanced search tab, and I was in a hurry. So I just put it up there. It has no attribution. I have no idea if it's protected or not. Now I'm assuming within this room, that's perfectly fair use. But if we put that up on the website, am I violating something?
Well, let me say two things. First of all, and I was going to address this near the end, there's a difference between infringement and plagiarism. Attribution has to do with plagiarism, as if you were claiming it as your own, instead of acknowledging it was somebody else's. It's not relevant to an infringement analysis.
Okay, that's good.
So, are you? Probably. Is it fair use? Maybe. What I advise my commercial clients is don't rely on a fair use argument, because the answer too often just depends on what side of the bed the judge got up on in the morning.
So, can I just offer the flip side of that story? So when I was preparing the blog post about Rob, I went to Flickr, which allows people, when they post their images, to define a Creative Commons license for their image. And you can search in Flickr, you can do, under advanced search in Flickr, you can do what Seth was saying. You can search only for images that have a Creative Commons license. So I found it wasn't the best image that was available, but it was the Creative Commons licensed image that I used there, and then I used another one by the same photographer. They were licensed as non-modifiable, so I didn't feel like I could crop the image to take anything out. I didn't feel like I could flip the image because the sign on the podium is reversed. I could use the image only as it existed on the site, and I had to give the attribution.
You're much more conscientious than I was.
Well, and that's a nice bridge, if I may. Creative Commons has a search engine, and they list some major sources that commonly use a lot of Creative Commons licenses, and you can just do your search in there. You can select whether you want to use it for commercial purposes. If you deselect that, you'll have more options. And whether you want to modify, create a version of it. You want to take the picture and then Photoshop it to make him look like Mephistopheles. That would be a modification that, if this box is not checked, you couldn't make, presumably. Yes?
This is a bit of a step back, but a lot of people are saying that one of the biggest obstacles that technology companies or digital media companies are facing towards moving forward is all the trademark filings that are being done, and that Google, one of the big reasons that they purchased Motorola was patents. Motorola was for patents, and this is just costing a fortune, and it's slowing everyone down, and it's just creating a marketplace that's just burdened. But it's interesting to me because I think about copyrights, and I don't. Maybe I'm not thinking of it from the 30,000-foot perspective, but I don't hear as much about that, about sort of frivolous copyrights to the extent that you have whole office buildings in Nevada of people that are just buying copyrights as they are for patents, and hoarding them and then suing people, buying them so they can go sue people because they're infringing on their patents.
Well, the body of law is fundamentally different. On the other hand, there is a business in Nevada, in fact, that is adopting a similar model to what's called patent trolls sometimes in the copyright realm. An organization called Right Haven that has taken assignments of rights from a number of different newspapers and are going after bloggers and other reposters of their content. They adopted their model without thinking it all the way through. They've been seeing some legal setbacks over the last few months. So you're not the first person to think of it.
It's not as bad, though, right? I mean,
I don't think there's a patent on that method of doing business.
The patent thing seems like so many people agree it's a really big problem, but it seems like the copyright world, that same type of problem doesn't really exist.
Well, everybody agrees except for the inventor who got a patent but never commercialized it, and so isn't very well known. And when they win a multi-million-dollar payout, they think it's a great idea, as do the people who pursue those actions. It's all good for lawyers.
So we have a few questions in the back there.
Yes, please.
Just to enlarge the scope of what we're talking about, my organization, we work internationally as well, and there is content that is submitted to us or that we use with a collaboration that we are in South America. How do the copyright laws or what we're talking about apply to international use? For instance, I'll give an example. If a colleague in this other country submits an article that is in Spanish and wants to post it on our website, now they don't have these kinds of laws in Ecuador, as an example. How does this work in terms of, is there some way to protect the information that is sent? Because it's his information, but it's posted on our website that's based here. So is there some way that we can protect that content as well? Or is this just sort of outside of the field of what we're talking about?
Well, it raises a whole lot of interesting questions that I can't really answer concisely here. I will say that jurisdiction, international jurisdiction, is an ongoing problem, an ongoing difficulty in copyright issues because the Internet's everywhere, pretty much. Every country has different intellectual property regimes. Some of them are sort of like ours. Some of them are very different. And the ability to enforce across borders is pretty limited, which is why, for instance, a lot of the peer-to-peer torrent sites are located offshore in places where they don't have strong enforceability and U.S. law can't reach them. That said, what rights you have in it when you post it and how you post it is going to determine how you can help enforce those rights.
Thank you. Okay. Sorry.
I think you both mentioned something called a DMCA agent. Can you just define what that is?
That's simply somebody who you designate on your website who is the person who will be notified when the DMCA action is triggered. So, and that's somebody who is also designated in the filing that you submit to the Copyright Office. It can be either a specific person, or you can just have just something generic like DMCA agent for your blog or your website.
It's a requirement under the DMCA, which is part of the Copyright Act, that you register an agent. The mechanism of doing that has been under an interim rule for about 13 years now. The Copyright Office is currently in a rulemaking proceeding. They issued an NPRM, a Notice of Proposed Rulemaking, in the Federal Register a couple weeks ago. And they are proposing to streamline and simplify the mechanism of registering agents in ways that are particularly helpful for large organizations that have a whole bunch of websites, perhaps, and whether they can do that under a single agent or not, and the methods and mechanisms and the online methods of doing it. They're reinventing. If you're interested, do a search or go to the Copyright Office or the Federal Register, the Government Printing Office site. You can find the Notice of Proposed Rulemaking, and anybody is welcome to comment on it. So if you have thoughts on how that should work. But you do have to, you can have a generic email address, but you do have to have an individual designated.
We have a question on the back.
Music on, if you, let's say you have a little video, like a little documentary video, and you want to put music on it. I seem to be very confused as to, you obviously can't just grab some music like, Elton John and put it on, but otherwise, what I keep on doing is going to sites where it's completely free, and actually it's not very good. So I just not quite sure what the process is for accessing permission, because it doesn't seem to be into the Creative Commons type of space.
Well, and briefly at a high level, it's a little confusing. Copyright is a bundle of rights that all have different licensing regimes. You need if you're putting with a documentary, you need to get a sync license to synchronize music to motion picture.
Even for like a 3-minute video on that's going to be up on YouTube and you're posting onto your site.
If you want to do it legally, yes. If you want to make a fair use argument later, maybe. That might be good. And the other thing is a public performance license, which you get from one of the 3 major PROs, public performing rights organizations. That's ASCAP, BMI, and CSAC, who you might have heard of. Yeah. They license the right to make public performances of it. Whether a YouTube video is a public performance or not is a separate question that's not entirely settled at this point, frankly. So it probably depends on who the stuff is and how they think you're misusing it or using it.
Right, and so when you're choosing it, you deliberately go for people who are not very prominent. You just go for people who probably aren't going to be bothered.
Well, that's the other option. As you said, there's lots of free stuff out there, what used to be called needle drop music, where you'd buy a record, and for the price of that record, you could use the music on it for anything. A lot of it sucks. The concept has expanded. Needle drop is an old term, obviously, referring to vinyl. But a lot of people are posting stuff now online for free use, and there'll be some kind of license associated with it. Finding something that's good and fits what you need is the hard part.
If it's not a megastar, you can always write to the artist also and ask them, and you'll be surprised they might say yes.
Unless I can get back in 2 minutes, which is the speed of everything nowadays. And just quickly, is a non-profit commercial use when it says commercial? Yeah.
Probably.
Well, especially if you're using
Can the
it for
podcaster jump in?
fundraising.
Yeah. No, not necessarily. It's for just for educational.
Can I just say quickly,
Can the podcaster jump in for a minute? We do a lot of productions that require production music, and there is a whole genre of music available, as Alan has indicated, used to be called needle drop. Today is referred to as royalty-free music. They're commercial houses. It's not very expensive. You can buy one song. You can buy a CD's worth of songs. You can pay in advance for multiple album purchases at a number of different sites. Some of it is even programmed in a way that you can alter it. There's a service called Sonic Fire, which allows you to download multi-layer tracks where if you don't like the fact that it has a lead guitar in it, you can take the lead guitar out using their software. And when you render out the music, there's no lead guitar in it. And you can change the moods, and you can do all kinds of things. And you can use it over and over again by paying once. That's why it's called royalty-free. And it is specifically licensed for these kind of uses. And very inexpensive, and I recommend it. It's actually very good.
Okay, Tom.
One other comment on that, which is YouTube has a whole, if you're specifically talking about YouTube has a large library of fairly popular commercial songs with which it has reached licensing agreements with the holder that apply to use within YouTube. And basically the model is that by using that song on your video, you are allowing YouTube to promote sale of that song through links typically from your video to some mechanism for buying that song legally. So that's another option for legal use of songs.
Right. Without going into detail, fair use is a complicated, multi-pronged decision tree with a lot of fairly subjective factors in it.
But those are two examples of licensed use.
True.
And
What you were talking about is promoting it for other kinds of use as well. Now that's can be used. That's one reason that artists make some of their stuff available free. It's also an argument, well, is it commercial, educational? What's the nature and character of the use? And that's what that's based on.
the other thing to keep in mind is that there's performance rights and there's publishing rights. So there's two different kinds of rights for the music. So if you find a piece of music, like let's say a piece of Bach that's in the public domain, and there's somebody on your board or some volunteer or somebody has a sister or a brother who can play piano nicely, then you're not using, Lang Lang's version of that Bach, then you're totally within your right to record somebody performing who's giving you their performance of a piece of music that's in the public domain. And then the last thing to keep in mind, which is not really technically fair use, but I just produced a 2-minute piece for the college that was basically an excitement generator about a bike ride for social justice. We pulled off YouTube a karaoke version of a Lady Gaga song and used it. Now, I'm a big proponent of doing things by the letter when it comes to rights, but is Lady Gaga ever going to care if 800 or 700 at the most people see this little thing for a rabbinical ceremony about food justice? No. Go ahead and use it, there are situations where it's okay.
No, this is what lawyers do every day, especially business lawyers. Is you say, okay, well, this is what the law is. Let's do the risk analysis. Is Lady Gaga going to want to sue you for that kind of use? No, probably not. She just looked stupid.
She looks stupid.
Is she going to want to sue Comcast for that kind of use? Yeah, probably. Deeper pockets, purely commercial enterprise. So you do the risk analysis and sort of factor that in against the, sometimes you have a small risk of a very large penalty. And those are awfully hard to calculate. So we're running way over time. Can I leave you with one little cartoon that shows one view? This is by Nina Paley also, who wrote this book, of why she thinks it makes sense to give all her stuff away.
Copying is not theft. Is not theft. Stealing a thing leaves one less left. Copying it makes one thing more. That's what copying's for. Copying is not theft. If I copy yours, you have it too. One for me and one for you. That's what copies can do. If I steal your bicycle, you have to take the bus. But if I just copy it, there's one for each of us. Making more of a thing. That is what we call copying. Sharing ideas with everyone. That's why copying is fun.
Okay, well, thank you. That's a nice, lively note to end on. And, we certainly, Podcast Steve,
I'm sorry. I just have to make one appeal to everybody
As a content creator and a producer of content for other people, we're talking about intellectual property here, and we've heard some comments where people say, there's not a risk in copying something from somebody else. If you want your content rights to be respected, you should think about respecting the content rights of the people you are copying from. And I just think, that's important.
And thank you for re-emphasizing that.
okay. Well, that's definitely a good point, and one that we can all think about. But there are, as you see, there's a lot of gray areas, and which is why intellectual property lawyers are never at a loss for business, right? So, anyway, all right. Well, first of all, thank you very much to Dina and Alan. Extremely informative and enlightening and entertaining presentations, which you could see we could keep going on and on and on. And we will have some time for people to you can come up individually and ask some questions. The links that Alan had, that he was showing up here, we will be able to send out to the group, so we'll be able to do that. As you mentioned, on your way out, if you haven't gotten the Mimi and Eunice's intellectual property, that's on the table, as is Dina's handout, which covered the aspects of her presentation. And then finally, again, I make my second appeal for anyone to come out with us after first we have to just clean up the room, and we allow time for all of you to just do some final networking. And if you have, as I said, some questions that you want to go one-on-one with Dina or Alan, that's fine. But we will be going out to Turnanog, which is our usual haunt, and we have a good time. It's just very low-key, casual, and you're all invited to join us. Thank you very much.
Thank you.